Hi there, it's Wendy Hernandez, the creator of Command the Courtroom. And today I want to talk with you a little bit about what role a child's wishes play in a custody case. And by that I mean does a child get to choose where they want to live? That's a question that I get asked all the time in my office. And most people think that once a child reaches a certain age, so say 12, 13, 14, 15, or 16, that automatically they get to make the call. And that's just not the case. A child's wishes is one of the factors that a judge is going to look at in deciding where the child should live most of the time, or what parent should get legal decision making authority over the children. But the child's wishes alone don't carry the day. The judge is required to look at all of the other best interest factors and decide how they interplay with what it is that the child wants. So, how old does a child have to be before a judge does consider what he or she wants? And the answer is not a one-size-fits-all answer. Really, the answer is when the child is of sufficient maturity to express what he or she wants. And different judges have different cutoff ages. I've heard judges say, oh, age 6 or 7, and other judges have said, no, 6 or 7 is too young. I'm looking for 9 or 10 years old before I'm going to consider their wishes. So it really depends on your judge, and it depends on your child's ability to express himself and say what the reasons are for wanting what they want. Another question that people have surrounding a child's wishes is, well, how do we get my child's wishes out in the open? How do we communicate this to the judge? Does my child have to go to court and testify? And the answer to that question is most of the time, no, a child doesn't have to testify. If a child is placed in a courtroom, that really puts a child in a bad position of feeling like they have the power, and it puts pressure on them, and they don't necessarily get to make that call. So what judges do in these types of situations most commonly is they have a third party interview, somebody who's qualified like a psychiatrist or a psychologist or a social worker or a court-appointed attorney, and this person interviews the child, and they interview the child in a way that the child doesn't feel like they're being pressured or like they get to make the call. The person tries to establish a rapport with the child, find out what's going on at mom or dad's house, and then this person, this third party, prepares a report that's provided to the judge and may be provided to both attorneys if both parties have attorneys, or to the parties. It just depends on whether the interview and the report is confidential or non-confidential. So the judge, in making the decision and weighing all of the different best interest factors, is going to look at this report. So if you have a child who's telling you that he wants to live with you or with the other parent, you should know that the child's wishes alone are not going to carry the day. There are a lot of other things that the judge is going to have to look at. So the child can't choose custody. There's best interest factors that apply in every state. So wherever you are, look at your child custody statutes, look at all of the best interest factors that apply, and pay attention to all of them, not just one of them. The child's wishes are not the only factor. So that's it for this video. Keep moving forward, keep the faith, and remember, I'm on your side when it matters most.